Welcome to The Explainer. Today we're diving into something really critical in India's new criminal law: how confessions are recorded. It's a whole process built to solve a really fundamental problem in our justice system.
So let's just jump right in with a question that really gets to the heart of things, right? Why is it that a confession, something that seems so definitive, is often basically worthless in court if it's made to a police officer?
All right, here's how we're going to break this down. First, we'll look at the core problem. Then, we'll see how the law tries to fix it. We'll dig into the safeguards, what happens when a confession actually gets to court, and then kind of zoom out to see the bigger picture.
So, what is this dilemma all about? Well, at its core, it really just comes down to one word: trust. Why does the legal system have this built-in suspicion of a statement given to the exact people who are trying to solve the crime?
And the law draws a super clear, bright line in the sand here. You confess to a police officer? Inadmissible. It can't be used against you. But you say the exact same words to a judicial magistrate, suddenly it's powerful evidence. So the real challenge is, how do you safely get from one side to the other?
This is where the law steps in. The answer is right there in Section 183 of the new Bharatiya Nagarik Suraksha Sanhita. You can think of this section as the official bridge, the one safe path for a confession to travel from the police station into the courtroom.
What this section really does is create a kind of protected zone. It yanks the whole act of confessing out of that potentially intense, high-pressure police environment and places it squarely under the watch of a neutral judicial officer.
Yeah, it's helpful to think of the magistrate here as a referee. They're not on the investigation team. Their one and only job at this moment is to make sure everything is fair, that the accused person's rights are being protected, and that whatever is said completely freely.
Now, the timing on this is actually pretty flexible, which might surprise you. A confession can be recorded while the police are still investigating, or even after they're done. But there is one hard and fast deadline. It has to happen before the official court inquiry or trial actually kicks off.
Okay, so how does a magistrate actually make sure a confession is voluntary? It's not just a gut feeling. The law lays out three very specific pillars of protection to make sure the whole thing is fair.
And these aren't just suggestions, they are mandatory duties. First, the magistrate has to tell the person, look, you do not have to confess. Second, they have to spell out the consequence very clearly. If you do confess, it will be used against you. And third, and this is so important, the magistrate can't just be a robot checking boxes. They have to actually question the person and become personally convinced that the confession is 100% voluntary, without any fear or pressure involved.
So, here's a critical question. Right? It's a real test of the system's integrity. Imagine the police bring someone in. The magistrate does their whole spiel with the warnings, and the person just says, nope, I don't want to confess. What happens then?
This is where a really vital safeguard kicks in. The accused is not sent back to the police. The law is smart about this. It recognizes that sending them back could feel like a threat, a way to apply more pressure. So instead, they're placed in judicial custody, which is under the court's control. It's all about removing that element of fear. And the whole thing wraps up with a formal, signed document. The magistrate has to write this little note, this memorandum, right at the bottom of the confession. It's a permanent record where they certify, yep, I followed all the rules, and I believe this was said voluntarily.
All right, so we have this carefully recorded confession. Now what? How is it actually treated in a courtroom? Well, it carries a lot of weight, for sure, but it also has its weaknesses.
And here's something really interesting, a subtle but super important difference. Unlike when a witness gives a statement, a confession is not taken under oath. And you might wonder why, right? Well, the thinking is that even an oath could be a form of pressure, and that would undermine the whole point of making sure it's absolutely voluntary.
This is a great illustration of how not all mistakes are created equal in the eyes of the law. Some screw-ups are curable, like if the magistrate forgets to sign, that can be fixed. But other mistakes are incurable. They're deal breakers. If the accused wasn't warned properly, or some court clerk recorded it instead of the magistrate, the whole confession is invalid, thrown out.
And this is a really key takeaway. Even a perfectly recorded, by-the-book confession is not a silver bullet for the prosecution. It's definitely powerful evidence, but the courts have said time and time again that you can't convict someone based only on that confession. It has to be backed up by other evidence in the case.
Okay, for our last point, let's just zoom out a bit. Let's see how this one specific procedure, recording a confession, fits into the much bigger machine of a whole criminal investigation. You see, Section 183 is really just one piece of a giant puzzle. It exists right alongside all these other critical investigative steps, like medical exams of victims, searches carried out by the police, and getting search warrants. And each one of those has its own set of very strict rules.
And that kind of leaves us with one final thought to chew on. This whole legal framework, it's all about a very delicate balancing act, isn't it? It's trying to let the state gather evidence while at the same time fiercely protecting a person's rights. It's this whole complex system of checks and balances. But the big question that always hangs in the air is, does it really truly remove all influence before a person even walks into that magistrate's room? That's something we're thinking about.